Good evening and welcome to our very formal debate this evening. For those of you who I don't know, my name is Ted Davis. I have the privilege of being the chairman of the Governmental Affairs Committee for the Leavenworth-Lansing Chamber of Commerce, and we're the sponsors of this evening's debate. Now, this may be a little bit different from what you're used to seeing. I'm sure you've seen plenty of debates on television which are candidate debates, and they scream at each other and belittle each other and things like that. That is not this debate. And that is the last expression of support until we get to the very end. So a formal debate begins with a proposition or a question. And the question for this evening's debate is, should the state of Kansas amend the state constitution to authorize the election of the state Supreme Court justices and abolish the existing state Supreme Court nominating commission? So that is the question that we're going to have as the focal point of our debate. To do that, we have a team that is the Affirmative Team. The Affirmative Team consists of Attorney General Kris Kobach. Prior to his election as the 45th Attorney General, Kris Kobach served as a constitutional law professor at the University of Missouri, Kansas City Law School of Law, clerked for the 10th Circuit Court of Appeals, and served as counsel to the U.S. Attorney General John Ashcroft. He litigated some of the most high-profile cases in the country, including a 2021 case on behalf of employers and employees affected by President Biden's vaccine mandates. A case that he won. He received his JD from Yale Law School and his undergraduate degree from Harvard University. He currently serves as he has served as the 31st Kansas Secretary of State. Currently lives in Douglas County with his wife Heather and 4 young daughters, and I believe one is here this evening. Welcome. We're glad to have you. His partner on the Affirmative is Joshua Ney, a lawyer in, down in Jefferson County. He served as the Jefferson County attorney for the past 10 years and has a private practice, having previously served as the Kansas Securities Commissioner. Josh currently serves as the bar-elect attorney member on the 2nd Judicial Nominating Commission, covering Jefferson, Jackson, Pottawatomie, and Wabaunsee counties. In 2020, Josh was selected by the local nominating commission as one of the 3 finalists for the district court judge position. He has researched and testified on Kansas judicial selection for over 15 years and has published a law journal article in 2009 in the Washburn Law Review entitled, "Does the Kansas Supreme Court Selection Process Violate the One Person, One Vote Doctrine?" Which was a peer-reviewed article. He grew up on his family's 6th-generation farm in southern Leavenworth County and attended Baser-Linwood from kindergarten through high school. So that is the Affirmative Team. The opposing team that will argue against our question consists of 2 local lawyers. First, Aimee Bateman. Aimee is an experienced attorney specializing in criminal defense, litigation, business and contract law, and military law with a focus on complex investigations. She is a graduate of the United States Military Academy, West Point, and earned her law degree from Texas Tech University School of Law. She graduated summa cum laude in 2008. The American Bar Association designated her as the outstanding young military lawyer in 2013. During her assignment with the 10th Mountain Division, she served in Kandahar, Afghanistan. Later in her military career, she served as the commanding judge advocate with the U.S. Army Special Operations Aviation Command at Fort Bragg. She finished her Army career as the Regional Defense Counsel here at Fort Leavenworth and is a retired lieutenant colonel. She founded Bateman Law Group in 2021 and is the managing partner. She is licensed to practice in Kansas, Texas, federal practices in the District of Kansas, and the military courts worldwide. Her partner in the opposing team is James Floyd. He is an attorney who represents people charged with crimes in Northeast Kansas, including Kansas City, Leavenworth, Johnson County, Lawrence, and Atchison County. He is a resident of the Kansas City metro area. He graduated from Duke University with a Bachelor of Arts in History. He then received his law degree from Washburn University School of Law, where he focused on criminal law, criminal procedure, evidence, and trial advocacy. James first entered the courtroom as an intern for Douglas County District Attorney's Office, where he worked on criminal cases, motions, and appeals. Next, he was a criminal defense and family law attorney with the Kansas Legal Services of Emporia. After leaving Kansas Legal Services, James became the Assistant District Attorney at Wyandotte County District Attorney's Office, where he prosecuted a number of cases ranging from theft to murder. He launched his firm, Floyd Law, in June 2021. He is licensed to practice law in the state of Kansas. He is a member of the American Bar Association and the Kansas Bar Association. Would you please welcome our panelists? Okay, a little bit about our format. In a few moments, I'm going to turn the floor over to our panelists. Round one, the affirmative team will begin, and they'll have a 5-minute opening remarks arguing for our question. Then, one of the members of the opposing team will also make a 5-minute presentation opposing the question. Round two, the second member of the affirmative team will present their 5-minute presentation, followed by the opposing team's second 5-minute presentation. In round three, we'll begin by the opposing team asking one question of the affirmative team. And the affirmative team will have 3 minutes to answer that question. At the end of which, then the affirmative team will ask the opposing team one question, and the opposing team will have 3 minutes to answer that. In the second go-round in that same session, the opposing team will ask its second question of the affirmative team. They will again have 3 minutes to answer, and then the affirmative team will ask their second question of the opposing team, and they'll have 3 minutes. Then moving into round four is your opportunity to participate. If you would like to ask questions, we would like to have you submit them in writing. Where's my assistant here? There we are. My two assistants here, who cannot do this job without, Kelly Butler and Jeanette Laby, have 3x5 cards. If you can get one of their cards, write it out, submit it to them. They'll get the questions to me, and then I'll ask those questions of the panelists. When we ask them, they will have 2 minutes to answer those questions. When we're finished with the audience participation, we will then have closing statements where each team, just one each, will have a 2-minute final statement. 1 2-minute statement by each team. So please respect the quorum of our formal debate and save your audience, your applause and your appreciation until the end of the debate. Yes. Oh, thank you so much. Appreciate it. It's my timekeeper. Remind us, panelists, she has a 2-minute alert, 2 minutes, 1 minute, 30 seconds, 10 seconds, and then finally stop. Is this being live streamed? No, it's recorded. It'll be posted on our YouTube channel. Thank you for asking. All right. Any comments or questions? To poll? I was going to wait until after. Poll. Yeah, do it after this. Since I don't have the electronic ways of doing that. So, any comments or questions? All right. So first up will be the affirmative team.
Well, thank you, everyone. It's an honor to be here. It's ironic that we're going to take a poll at the end of the evening. I assume everyone is thinking in that poll it's going to be one person, one vote. But if we were conducting the poll in the same manner as our current judicial selection system, any attorneys in the room would get 20 votes and non-attorneys would get 1. The current system doesn't just give exponentially greater voting power to the registered attorneys in the state, it allows those attorneys to elect the controlling majority of the nominating commission. No other state in the union does this. Can you imagine if today's proposition was whether Kansas should allow lobbyists to select our legislators or business professors to elect our governor? Those proposals would be laughed out of the room. It reminds me of the Buckley quote, "I would rather be governed by the first 2,000 people in the telephone directory than by the Harvard University faculty." But that's exactly what we've done with our current judicial selection system. We've outsourced democracy to a trade group. We've established attorneys as a nobility class, a House of Lords, if you will, that controls who can become a Supreme Court justice in Kansas. That's oligarchy, not democracy. So what does the debate proposition as reflected in the ballot language do? The amendment replaces 655 words in the state constitution with 4 sentences. Each of these 4 sentences fixes a problem in current law. First, it would establish that Kansans have the right to elect the justices of our Supreme Court. Kansans are taking back what they gave away to a trade group. Second, all other process questions will be established by law. We're not going to over-constitutionalize our system this time. It allows Kansans to improve their system over time. That means there can be debate in Topeka about nonpartisan or partisan elections, campaign finance regulation, standards of judicial conduct. These can all be regulated just as they are for other elected offices. Third, staggered elections. This fixes 2 problems. First, due to a quirk in our current system, in 2028, we will have 6 of the 7 justices on our Supreme Court up for retention vote. That's absurd. Second, it prevents judges from timing their retirements to line up with the governor of their choice. Judges will need to run for re-election regardless of the political winds. And finally, it will establish that vacancies are to be established or filled by election, not appointment. This fixes the 1958 triple play, which was an appointment scandal, not an election scandal. Ironically, that's the only thing the 1958 amendment didn't fix. Within the last 22 years, we've had 6 justices choose to retire under a single governor, and 5 more justices retire under another governor. Both governors belong to the same political party. So I want to make the case that this proposition is principled, popular, and precedented. Kansans like to elect their government. We have 6 statewide officials, not 1 president. We have State Board of Education, 165 legislators, 8 county-wide officers in every county, 291 school boards, 628 city councils, not to mention townships, electric co-ops, and other local boards. We know how to do this as an electorate. So Kansans can be trusted to determine what makes for a good judge, just as much as they can determine what makes for a good governor, school board member, or county register of deeds. And a good judge is independent, neutral, competent, has judicial temperament, and can fairly adjudicate disputes without respect to persons or special interests. Voters know how to discern and select good judicial candidates for their judicial qualities. Second, it's popular. Elections are the most popular model for selecting judges in the 50 states. They're also the most popular model in the state of Kansas. 55 of the 105 counties elect their district court judges, and that includes Sedgwick County and Wichita County, 2 politically opposite counties. And finally, it's precedented. Kansas adopted judicial elections for Supreme Court justices in 1861 and kept that in place for 100 years. Kansas was born during a populist era and has kept that populism throughout the state and local government since. Unlike the bar, the electorate is far more capable of screening candidates in a less consistently partisan manner over time. Since 1965, the Kansas electorate has not elected a governor of the same party as their predecessor. In other words, the last 10 elected Kansas governors have alternated between Republican and Democrat. Kansans know how to change their mind, and they know how to reward competence. We can trust Kansas voters to pick their own government.
Thank you.
The question before us is whether or not we should change our current Constitution. The real question underneath that is whether Kansans want fair, impartial, and independent justices. The current system of nominating justices includes a panel of 9 individuals, 5 attorneys and 4 non-attorneys. The 5 attorneys are elected by or from the Kansas congressional judicial or congressional districts by attorneys that live in those districts. The 5th attorney is elected by all the attorneys in the state of Kansas. The 4 individuals that are non-attorneys are appointed by a governor, and these individuals serve on staggered terms. The system in place now, those individuals select applications or receive applications from any member of the bar who's 30 years old and wants to apply to be a justice of the Kansas Supreme Court. They cull through those applications and they do background checks and they look at the judicial temperament, they look at the work or the body of work of each of the applicants that go before the committee. After they look at those things, they send 3 of the individuals that they feel are the most qualified to the governor, who then makes an appointment. Those individuals are then subject to a retention election to see if the people of Kansas would like to keep them in the position that they've just been nominated for and are now working in. The system that our opponents propose would include money, politics, and the impartiality and the independence of the judicial system will be greatly diminished. And to get to that point, you have to look at what is the role of the court and the government, right? There are 3 branches of government, right? Everyone knows that. There's the legislative branch, the executive branch, and then the judicial branch. And they each have their own unique functions. The legislative branch and the judicial branch, the executive branch, are both what we would call political branches of government. The legislative branch, it's easy to see. We nominate or we elect individuals every 2 years. Those individuals go to the House, they go to the Senate, and they try their best to look into the future to see what laws would best help our society flourish. And then you look at the governor, sort of a derivative of the legislative power. Their job, or the governor's job, is to enforce the laws. They are looking at not the future like the legislature, but they're looking at today. How can I best implement the laws to help society flourish today? Which also has a bit of discretion, which means there is a bit of politics. Because as Aristotle once said, human beings are indeed political animals. But when you look at the judiciary, their job is not to look into the future or to look into the present or look at the present. They are stuck with looking at the past. They have to look at the facts of the cases before them and apply the law that existed at that time to those facts. So the judiciary's role is inherently apolitical. But our side would like to inject politics into how they make their decisions. Now, the judiciary, again, they look at the facts, they look at the law. They need to be insulated from the political winds so that they can impose or they can give their fair and judicious opinion. They can't give a fair and judicious opinion if every couple of years a big case comes before them and they have to wonder whether or not if the decision I want to make is going to cause me to lose the job that I currently have. The work of the court is antithetical to politics. Courts, the justices on the court, they have to look at the law, they have to apply it even-handedly, and they have to do that without bias. They have to do that without influence. By electing our justices, we would inject bias and influence into what our judges or the decisions that our judges make. So the proposed amendment is a solution in search of a problem. The current system has existed for nearly 70 years, and it has worked. And it'll work for the next 70 years and the 70 years after that.
Thank you and good evening. It's a pleasure to be here tonight talking about a very important constitutional question. I wish all of the people in Kansas would listen to a discussion of the issues that is this sober and this serious. So Kansas has had the current system, which is called the Missouri model. That should have been our first clue. It was a very bad idea. The Missouri model, as we've heard, uses so-called experts who are controlled by 5 of the 9 votes being attorneys to decide who gets to be on the Supreme Court of Kansas. I will begin with one assertion, and that is that the current system has produced a poor court, a less than optimal court in terms of its merits. And a elected court would be a superior court. And I'm not just saying this because it's my opinion, I will give you numbers to back that up. The so-called merit-based system we have right now has made Kansas the most overturned state Supreme Court in the country. The last time a decision of the United States Supreme Court, the last 8 times a decision of the Kansas Supreme Court went to the U.S. Supreme Court, in 7 out of 8 cases, the state Supreme Court of Kansas was flipped. That is an 87.5% failure rate. The normal should be 50%. The U.S. Supreme Court only takes 2% of the cases presented to it, and those are the cases that present very close questions. And you would expect typically a state Supreme Court would win half the time and would be overturned half the time. But in Kansas, it's 87% overturned. In the infamous Carr Brothers case, which was about the murders in the Wichita area, the Kansas Supreme Court bent over backward to stop the death penalty from being applied. The U.S. Supreme Court overturned the Kansas Supreme Court in an 8-1 decision. 8-1. Only Justice Sotomayor thought the Kansas Supreme Court got it right. The U.S. Supreme Court used the following words to describe the shoddy reasoning of the Kansas Supreme Court. Quote, untenable. Quote, based on only the most extravagant speculation. Quote, and quote, beyond reason. Quote. During oral argument in the companion case that very same day, Kansas versus Gleason, Justice Scalia asked regarding the Kansas Supreme Court, quote, did the Kansas Supreme Court read these U.S. Supreme Court cases? End quote. This is very rare for the United States Supreme Court to use such disparaging terms to describe a state Supreme Court, but they have used it repeatedly with regard to Kansas. It is an embarrassment for Kansas. Secondly, I would argue that states with elected Supreme Courts are better Supreme Courts. And I'm not just saying this because I think so. Empirical research shows that it's the case. Choi, Galati, and Posner did a study of this, measuring the productivity, independence, and opinion quality of elected justices, which 22 states have, versus justice selected through the Missouri model, which 13 states have. They found that elected judges were more productive, writing more opinions per year, more independent, meaning they were willing to differ from their colleagues, and in terms of quality, it was a wash. Quality being defined as the number of times they were cited by other courts for authority. And finally, I think the point to be mentioned here is we had elected justices in Kansas for 100 years. There was no problem with opinion quality. There was no problem with politicization. None of these problems existed. 22 states have continued to use this method, and we should go there too. The claim that was made in the preceding speech by my opponent was that elections will politicize the court. Now, the problem with this assertion is that it assumes that there is no such thing, that there is such a thing as non-political cases that go to the Supreme Court, that there's neutral, no unbiased decision-making in our courts. It is true that in some cases there are cases that are very technical, cases that are numerical about what the balance should be on some question. But the cases that go to the Supreme Courts of the states are almost always close questions. And in those close questions, you will usually have people in the majority and in the dissent. There is a gray area as to what the Constitution requires. There is a gray area as to what the law states. And in those cases, a justice's partisan inclinations and ideological leanings will come into play. That is why those of us who do appellate legal practice can tell you exactly which way the justices will vote. To pretend that they are impartial when deciding these great controversial questions is an illusion. That is not the way it is. So the question is, if there are going to be ideological leanings, if there are going to be a little bit of judicial politics in these decisions, would you rather have them be in an unaccountable fashion, where judges are accountable to no one? Or would you rather have it be in a fashion where they are accountable to the public, so the public can say, you know what, you crossed the line there, and this other justice is better? I say, make them accountable to the people. Thank you.
Well, I'll start with the last point that was made about making this accountable to the people. Our current system and the current way in which we select and retain our Supreme Court justices is directly accountable to the people. In a direct vote, we have a retention vote. That part is been conspicuously not mentioned as far as how we maintain our Supreme Court justices. So Mr. Floyd explained how they come to be and the commission and how they're picked. And then immediately after the very first general election, after someone is placed on the Supreme Court, they are placed on the ballot for a direct vote of all the citizens of Kansas. They get to decide, if the commission and the governor made a correct decision, they get a retention vote. And then that person comes up for vote again every 4 years. They come up again for another vote, for a retention vote. That is direct democracy. That is the voice of the people. That is absolutely a core and fundamental part of the system that we have. So to say that we should scrap a system that has been in existence for almost 70 years and to have that supported by anecdotes and cherry-picked data is very concerning. Because here's the statistics that were cited about there being an overturn rate of 83.3%. Okay, so we've had this system in place since 1958. That's only the overturn rate from 2007 to 2025. And how many cases do you think were overturned? 5. 5 of the hundreds of cases that came out of our Kansas Supreme Court, 5 were overturned. 5 out of 6. But the idea that you would expect it to be a 50-50, that's just not the way it is. Cases that are selected, that are granted cert by the Supreme Court, are overturned more often than not, nationwide. The nationwide overturn rate is 77%. What is the overturn rate for Kansas for the entire period that we have had this merit-based selection system? 73%. So if that's the metric that we want to judge as far as this being a poor court because they are the most overturned court, that is just flatly not true. Kansas is not historically the most overturned court under the merit-based system that we have had since 1958. More productive, churning out more decisions, that doesn't mean better. That's a very subjective thing to say, that just writing more decisions is better. Maybe it's because they're worried about their next election. They've got to churn out more so that they have more of a body of work that they can show in these elections that they are now going to be forced to subject to keep their job. And the issue of close questions, yes, these are often very close questions that come before the court. That's what makes appellate work so challenging and so interesting and so much the necessity for having the best, brightest, the best judicial temperament and scholars that we can have on the court. Do you want those judges who are taking those very, very close, difficult questions that will affect all of the citizens of Kansas? We're not talking about just an elected judge in Wyandotte County. We're talking about 7 justices that represent all of us. That is the last line of defense for our rights, our property, our way of life in Kansas. And do you want them thinking about money? Do you want them thinking about their next campaign? Money equals indebtedness. When you take money from someone, it is very, very, very hard, even among the best of us, to not have that in your psyche and in your mind. And that should never be in the mind of our Supreme Court. That should never be in the mind of the 7 people who we rely on to maintain our way of life in Kansas. When you go to the ballot in August, the amendment will be on the ballot and there will be an explanatory statement. What is conspicuously missing from that explanatory statement among the 655 words that are going to be deleted out of our Constitution if this amendment passes is the fact that the prohibition against political activity will be gone. That prohibition against political activity has existed since the voice of the people, since Kansans amended the Constitution back in 1958 to have this be an impartial and very extensively vetted court. I know I only have like 10 seconds left, but I'm going to reach over, James. We're going through this process now. On March 16th, it was announced that there is a Supreme Court vacancy. And if there's any lawyers in the room that have been practicing more than 10 years, you have until April 17th to submit your application. An extremely extensive application, deep vetting, background checks. That's the system that needs to remain, and that is the system that will protect us most as citizens of Kansas.
Thank you, panelists. That completes round 1 and 2. Round 3 is your questions to each other. So we'll begin by the opposing team. What is your question for the affirmative team? Affirmative team, you'll have 3 minutes. Yeah, please.
So voting yes on this ballot amendment would get rid of the constitutional prohibition of Supreme Court justices affiliating with political parties and making campaign contributions. How can you assure Kansans that if this amendment passes, justices' interpretation of the law will not be influenced by them directly receiving money from special interests and political parties?
Thank you for the question. The problem with the 1958 amendment is it over-constitutionalized the process. It made it so the people cannot change the law to conform to changing circumstances. Because it's elected judges, obviously judges would have to run for election. They currently run for retention election, and we don't know to this day how many millions of dollars were spent in 2016, 2018 by 501c4s and other groups that are not regulated at all in the retention elections. So this problem already exists in Kansas. There's already a politicization of those retention elections. Even so, no Supreme Court justice has ever not been retained, and only one district court judge in the history of the Missouri Plan has not been retained, even though millions of dollars are spent. If you're an attorney in this room, you're used to on election day getting multiple texts about, I don't know any of these judges. How should I vote for them? That's because we have a prohibition, or a lack of incentive, I should say, on free speech. We have a lack of incentive on informed voters in retention elections. There's no marketplace of ideas when it comes to an up or down vote on someone you've never heard of. If I polled the audience today and asked you to actually name one of the 7 justices of the Supreme Court, I'm sure most of you couldn't do that because there's no incentive to actually compete. The question is this guy good? Or is this guy good? Is this guy bad? Is this guy bad? I don't know. And that's why we have statistically a 70-30 retention rate going back to 1958. It's always the same. But in 2016, 2018, we did have a lot of those types of warring of ideas, but it was money, dark money, that we don't know anything about. We don't know who gave to the Justices Retention Campaign. We don't know who gave to the Don't Retain Them, campaign. So this problem exists currently, and it's something that has scratched my head why proponents of the current system, defenders of the current system, aren't interested in reforming the current system. And that's because they control it. They control it through silence. And so the way that you fix and prevent politics in the worst version of politics is to have regulation. Every other state that has direct elections, whether nonpartisan or partisan, this constitutional amendment does not establish whether it's partisan or nonpartisan, statewide districts or geographical districts. That's left up to the law. Every other state has those campaign finance regulations. So ultimately, when the proponents of the current system are asking you to believe that this would create politics, what they're saying is voters can't be trusted with free speech. What they're saying is we need an exception to democracy. I think that's wrong, and I think that we need to change.
Thank you. Affirmative team, what is your question for the opposition? Opposing team, you'll have 3 minutes.
As we've discussed, Kansas elected its justices for the first approximately 100 years of our state's existence, and a majority of the counties, 55, continue to elect their district judges today. We have argued that the system works extremely well. We've also pointed out that the change in 1958 after the so-called triple play was not a problem with the elections. It was a problem for what to do when there's a vacancy. And it was the absence of an election that caused the foul play in that instance. So my question to you is, can you name a single judicial election in our state's history, either in those first 100 years of state Supreme Court elections or in more recent years in those 55 counties, in which the election produced any of the negative consequences you proclaim or resulted in an unqualified justice or district judge sitting on the relevant court? Please be specific if you can name one.
Can I name a justice that was influenced by politics? Sorry, you can't hear me? Can you hear me now? Okay. I do have a soft voice. I'm sorry about that. To be frank, no, cannot. Cannot do that. Look back through the 100 years before the constitutional amendment. Can't say specifically for sure that there was politics being played by the justices. But that was a different landscape before the constitutional amendment. 2010, I believe that was when Citizens United was decided. It has changed completely how politics and money works in politics. And I don't think at all in any way that if we change this system to what is proposed, that we would be able to prevent the dark money that my proponent talked about earlier from creeping into elections. It was brought up that these elections we don't know if they'd be partisan or by district, but we do know they'd be partisan because the part of the rest of the constitutional amendment is allowing the judges or the justices to participate in political parties and hold offices. What else would it be unless it was going to be partisan? We can call it nonpartisan if we like, but we'll know by the backing what their leanings are. So did justices back in 1888, were they influenced by the money or in the politics? I couldn't say yes or no. I have no clue, to be honest with you. But I do know that the landscape today is conducive to all the things that we're telling you would happen. That judges would receive money from individuals that might even appear before them in the courtroom. Could you imagine being on one side of the courtroom and you know the attorney on the other side is a big donor to the individual that's going to make a decision that affects your life? No Kansan should be subject to that. The current system doesn't allow that, and we should keep it as such.
Thank you. Opposing team, what is your second question? Affirmative team, you'll have 3 minutes to answer it.
In 2022, the average number of yes votes to retain Kansas Supreme Court justices was 587,201 Kansans per justice. That same year, Attorney General Kobach was elected with only 506,817 votes. Please explain why the more than 506,000 votes for you, Attorney General, constitute the voice of the people and democracy in action, but the more than 587,000 votes to keep Kansas Supreme Court justices on the bench does not.
I'm so glad you asked. The 587,000 people voting to retain a justice is exactly the point we're making. Nobody loses these elections. Why does nobody lose these elections? Because there's no opponent. There's nobody who has the incentive, has raised the money, and has the ability to make the case to the people of the state that this current sitting justice is unqualified. It is a joke to think that we have elections and we have the popular check on the system right now. Right now, as we've noted, no incumbent has ever lost a retention election. I would love retention elections where I don't have an opponent. I too would win by, who knows, 90%, 95%, 99% of the vote if I didn't have an opponent. It is comparing apples to watermelons to compare competitive elections to elections where you have no opponent. And this mirrors the experience of the other states that have something like our current system with retention elections and the Missouri model of initially appointing the judge. Even in other states, incumbents lose a tiny 1.3% of the time. In Kansas, they lose 0% so far. This is in contrast to the competitive elections of those 22 states that elect their justices. Incumbents lose 14.9% of the time. Yeah, there's an incumbency advantage. There's an incumbency advantage for other offices too. But incumbents lose a much higher percentage of the time when there's actually an opponent against them. So to compare the votes I got in a competitive election to the votes that a justice gets in an election without an opponent is ridiculous. Counselor, make an argument where you have an analogous situation. But I want to expand my answer to your question and say, let's compare attorney general elections to Supreme Court elections. The qualifications of an attorney general are pretty close to what the qualifications should be for a judge. You have to analyze complex questions of law. You have to analyze the wording of statutes. You have to be willing to defend the Constitution and articulate what the words of the Constitution mean. Those are the same criteria that we use for justices. Those make for good justices as well. Why is it that the people of Kansas are qualified to elect their attorney general, but not qualified to elect their justices? The people are perfectly qualified. My opponent, when I ran for office in 2022, I put my record out there, my CV out there, my experiences, and the people said, this guy seems more qualified than the other guy. My opponent coming up can make the case that Kris Kobach has done poorly as Attorney General, and you are capable of deciding. You are equally capable of deciding who the best Supreme Court justice would be.
Thank you. Affirmative team, what is your second question to the opposing team? Opposing team, you'll have 3 minutes.
Thank you. At the legislative hearing on this amendment, Kansas Bar Association board member Fred Logan was asked why he doesn't trust voters to pick judges if he trusts them to vote in retention elections. He responded, "I trust voters in the right circumstances." Do you agree with him? And if so, in what circumstances do you trust voters, and in what circumstances do you not?
And I do trust voters to have that governing check on the Supreme Court. I find it very insulting to think that 500 and I've forgotten my number now, right? 587,000 Kansans just randomly voted yes. They didn't have to vote. Part of it in the previous testimony that I've seen, part of the proponent's testimony before the legislature to get this on the ballot last year was arguments such as people don't even get to the end of the ballot. They ignore the Supreme Court justices. They don't even care about the retention vote. They don't know about the intention vote. 587,000 Kansans voted to retain those people because when you pick the right people from the job, you don't fire them. These are people that have been properly vetted, that have engaged in public hearings. There is a direct voice in the commission that picks these. They take public comment without any reservation and without any limitation. Again, like this process is going on right now. So I would encourage anyone, before you go to the ballot in August, and please go and have your voice heard in August. If this was about having, I have some question as to why this is on the primary ballot and not the general election ballot this year. If this is really about having the complete and total voice of the people heard in the state of Kansas. But this process is going on right now. As I said, you have until April 17th, if you are an attorney in Kansas, at least 30 years old with 10 years of practice, to throw your hat in the ring. And then at that point, those applications go to the commission. They are given very specific criteria that to look at these people, a very holistic look. And the public is encouraged to also offer their comments to the commission and to watch this. And you can go and you can watch the previous round of this. There's a YouTube channel. It's the Kansas Judicial Branch channel. And you can go back and watch the previous 8 hours of interviews that were done for the last group of candidates that came forward. And when this happens coming up here in the next 60 days, you can watch that again too. And then if you don't like the people that are selected and that are put forward, those 3 people to the governor and to whom she selects, then you can go, and I implore you to go to the polls, to have your voice heard. That is direct democracy in action, but it is governed by, to say that this is an oddball system or something that's very bizarre. I'll share, you heard, part of my background. When I am also a Texas attorney, and so it's interesting, in front of my mind when I thought about this is a case called Pennzoil v. Texaco, which I encourage any of you to go look at and to see that there are hundreds of thousands of dollars by the attorneys who were representing Pennzoil and Texaco went directly to the campaigns of the sitting judges on that appellate case in the state of Texas. So please, understand that there absolutely is a voice of the people, and we trust the people, and we trust them in the current system.
All right, thank you very much. All right, now we'll begin with your questions. We've got quite a few of them. I'm not sure we'll be able to get to all of them in the time that remains. Each team, the opposing and the affirmative, will have 2 minutes to answer the question. You just need one person to answer the question. Question number 1 from our audience. The current merit-based selection process requires the Supreme Court Nominating Commission to select the nominees based on the criteria of legal expertise, character, ethics, and temperament. There are 3, he says there are 3 more criteria. Does anything in the proposed amendment encourage or urge voters to look at the same nominating commission criteria when voting?
I'm glad you brought up nominating commissions. If you have watched a Kansas Supreme Court nominating commission proceedings, raise your hand. Okay, we've got a handful of people in this room of maybe 70. I have. And the reason that we can watch those proceedings is a result of a 2016 law that opened up those nominating commissions to the Kansas Open Meetings Act. Before then, the deliberations were closed. I helped write that law. I also helped write a law this year after finding out that you couldn't even get the candidates for the nominating commission before the filing deadline. For the attorney members on the bar. You call the Supreme Court and you ask to get the names of the candidates, and they will not release them because under a Supreme Court rule, I don't know what the Supreme Court is doing regulating the nominating commission, but under a Supreme Court rule, that is was closed. And now the legislature, with the signing of the governor, that is now open. But I have watched these proceedings. I would say that the lawyers are the worst people to be picking and selecting these judges in this room. This is an exchange that I witnessed. One lawyer member says, because our meetings are public now, some of us have trouble saying one candidate is better than another. Another attorney member, it's awkward to discuss personal characteristics with people staring at you. A non-attorney member, this is our public duty. We shouldn't feel embarrassed. We have to look at, a lawyer member, we have to look at these judges. I don't want to say something critical because I have to appear in front of them. a non-attorney member, are you fearful of retaliation? Lawyers have a self-interest in asking softball questions. I'll just list a few. I see you have ballet experience. Will there be a Spokane ballet show at some point? Will you rotate law clerks or have permanent clerks? All done within a 20-minute interview. This is no Bork hearing. This is no Kavanaugh hearing. These are softball questions. It's an ineffective system.
Please.
Sir, I believe the question was, to go back, it was, will the voters still, is there anything to
Oh, the
prevent them-
criteria. Will the change, will it encourage the voters to use the same criteria that the current selection process uses?
Well, here's what I'll offer is, as someone who's run for partisan political office, which we would expect these to be, because as it was pointed out, the one of the other concerning things in this amendment is that it gives a blank check to the legislature. It's in the language of the amendment, it says established by law. So it is not in the amendment, it does not say whether it be partisan or nonpartisan. That is going to be established by law, which means the legislature is going to decide these rules. And I would expect that these would be partisan elections. And if not, candidates will be endorsed by one side or the other, most likely. I wish in partisan elections, the things that were highlighted were your character, your temperament, your experience. Having been through this process, I can tell you that those were not the things that were highlighted about me. Those were not the things that went out on the mailers. Those were not the things that were in the nasty YouTube videos. Those were not the things that hundreds of thousands of dollars were poured into in trying to make sure I didn't get elected. Those weren't the things that were at the forefront of people's minds when I knocked on their doors. They didn't ask me about my character. They asked me what party I was affiliated with, and asked me very specific politicized questions. So I would like to think that people would still pick our justices based on their character, their judicial temperament, their life experiences. I think the questions that Mr. Ney pointed out in his testimony, if I'm presuming he picked the worst questions he could find, and these were wonderful questions. What challenging ethical dilemma have you faced? These are questions that Mr. Ney picked out as horrible questions. These are the questions that people should be asked, and we should want our justices to be held to.
Thank you.
I'm sorry. I'm having trouble coming with my timer. It's done. Sorry about that.
I'm going to ask two questions because I think they they're different, but yet they have a central theme together. As seen in recent school board elections, outside money is poured into conservative candidates. How can you assure that would not happen with the judges? I think related to it is the second question. How can we trust our justices if they can explicitly be given money by parties and special interests?
Well, I don't think this will be a very tough question. You can't ensure that outside money won't come into the election. At least according to the current United States Supreme Court definitions or interpretation of speech, anyone could put as much money as they wanted into picking or at least trying to convince others who a judge or justice should be. So I don't think it would keep it out in any way at all. And that raises the second point. How can you trust a judge whose job depends on whether or not he or she is elected? What happens when that 50-50 question comes up in front of the justices, and right before they're about to make their decision, they look at the calendar and they see, oh, it's an election year. How can we ensure that those justices in that situation do, I'm going to say the right thing, and by that I mean interpret the law fairly, impartially? How could we expect that? Be very difficult. I believe that in that situation, even if the justices themselves aren't being unfair, Just the mere appearance of that is so degrading to the integrity of the court that we shouldn't allow it in the first place. That's why we shouldn't amend the Constitution.
We can do all sorts of things to ensure that money will not have untoward effects in the judicial elections. First, the legislature can do what they do with all other elections in Kansas and impose contribution limits. So those limits have been around forever. You can do very low limits, like $200 or $500, which you see for some local races. You can do higher limits, like $4,000, which you see for governor or attorney general. You can pick your limits, and that will influence the amount of money that comes in. Second, you can force disclosure so that every judicial candidate has to disclose exactly where the money came from. Third, we already have the Judicial Code of Ethics, which prohibits a judge from, and this applies in the 55 counties that have elections right now, prohibits a judge from giving any favor or any bias or any benefit. And our judges are extremely conscientious about that. You can do it something else the legislature would have an option. They can do what New Mexico does. You can have public funding of elections, where essentially the taxpayer funds the elections and it's divvied equally between the two candidates. That is a perfectly acceptable system and is constitutional. Now, this question is often based, or this query is often based on the Wisconsin election of 2025, where millions and millions of dollars, tens of millions of dollars flowed in for one Wisconsin judicial election. The reason you can't use that case as an example or a credible or an analogous one in Kansas is because Wisconsin holds their Supreme Court elections in April, when no other election in the country is happening. So all of the political money flows into Wisconsin for those races, and they always have a lot of money spent. But if you have those races in November, when all the other races are on the ballot and all 50 states are moving, then you see far different things. And this would be the more comparable one. In West Virginia in 2024, the average amount spent by both candidates, $240,000. In Minnesota, $129,000. In Oregon, only $20,000 combined for both candidates. That is what a Kansas judicial election will look like, not Wisconsin.
Thank you. Another two questions that I think are associated, so I'll ask both. First, the Kansas Constitution says that all political power is inherent with the people. Should we honor founding principle and restore power to the people? Associated with that, I believe, why aren't the voters qualified to have a role in the selection of justices? Affirmative team, please go first.
Well, I talked in my opening about how I see this, and that's as a lawyer, someone who is part of the so-called House of Lords in Kansas, or the nobility class. I was not good at science. I wasn't going to med school. I was relatively well-read and could get through an LSAT and 3 years of law school and take the bar exam, and that qualified me to be part of the noble class in Kansas. That has been revolting to me since law school, as a principle-based argument, not as a real politic-based argument, but simply as a principle-based argument. I see it as Federalist 39, and I'll quote from this, James Madison in Federalist 39 talking about the Republican form of government that's guaranteed in every state of our union. He said it is essential to a constitutional republic form of government that it be derived from the great body of the society, not from an inconsiderable proportion or a favored class of it. I agree with that. I frankly have sworn an oath to uphold that in the U.S. Constitution. We've heard definitions of judges in an appointment model like the nominating commission. Antonin Scalia had a good quip that a judge is a lawyer who knows the governor. On nominating commissions and insider control, I quoted this in my Law Journal article in 2009. Boss Tweed of the Tammany Hall political system in the 1910s and 1920s said, I don't care who does the electing so long as I do the nominating. The problem with the current system is it throttles and prevents people from putting in for these positions that know they have no chance of getting on. I won't be putting in because there is a certain amount of real politic of what the definition of merit is. And merit, so-called merit selection, they never really get around to defining what they mean by merit. And I think a Scalia or a Kagan are equally meritorious. That has not resulted in Kansas.
So the Kansas Constitution does say all political power is inherent with the people. But as I discussed earlier, when we look at the three branches of government, there are two branches that are political. The third branch, the judicial branch, is not. Now, my opponent quoted Federalist number 39 regarding a republic, democracy, by Alexander Hamilton. Alexander Hamilton also wrote Federalist 78. And in Federalist 78, he talks about why judges should not be subject to the whims of the political passions of the time, why Supreme Court justices of the United States are not elected. They're appointed with the advice and consent of the Senate, and they serve for life. Why? Because it is their role, it is their job. They are the bulwark, as he continues to explain in Federalist 78, between the legislative and executive branch and the people, because the justices, their role is to interpret and enforce the Constitution. And sometimes that requires the justice to tell the executive or the legislative, you can't do that. And they can't tell them you can't do that if they are controlled by that party, such as the amendment would do. It would allow the legislature to decide how the elections take place, who can vote for whom, and when. The current amendment proposed would weaken the judicial branch, the branch of government that should be the least political, and the branch of government that was designed for judicial review so that it could protect not our rights, as well as the encroachment of the powers from the political parties or the political branches on the people. And the second part of that question was why the voters not qualified to do that. It's not that the voters are not qualified to select judges. But when you think about what a judge does, that sort of work is of such specificity and expertise that it's difficult for the general populace to really want to care about what's happening. It's boring, to be frank.
Next question. Does the current system give lawyers more power than your average voter in state government? Opposition, please start.
So the question is, does the current system give lawyers more power than your average
Voter.
voter? Well, I think, again, this goes back to what Mr. Floyd just talked about, is when we talk about where political power should lie, that should lie in the direct voice, in the direct elections of your legislatures, of your other state officials, of the governor. It shouldn't lie in, this should not be a place where we see political power and political influence exerted. Again, we are talking about these 7 individuals that stand at the top of our judicial branch in the state of Kansas, the 7 people that we are relying upon for their expertise, their experience, their judicial temperament, their independence to protect our rights, to protect our laws, to protect the system without regard or without influence to outside money and that sort of thing. So we should have, and this is, again, to the point that this is a very odd system or something that is peculiar or without compare. I'm a product of what I will humbly say is the best meritocracy on earth, and that's the United States military. Every single lawyer, in order to be a lawyer in the military, I became a lawyer through a merit-based selection process through a board that was half attorneys and half non-attorneys. half people that understood my qualifications, my intellect, my ability to analyze the law, and the other half were the people I was serving, soldiers and commanders in the field. Every job to come into the JAG Corps, that was the selection process. Every promotion I had, that was the composition. Because we are answerable to the people, and they are a part of that commission. Half of the commission, 4 of the members, they come one from each of our congressional districts. One is from Bartlett, which I believe has about 65 people live in that city. We have people from all over Kansas that are part of the commission, that are part of the process, and it is absolutely still gives a voice to the people, again, through the retention elections as well.
Affirmative.
I don't think I heard a clear answer to the question. Does the status quo give the lawyers more power? Of course it does. Every so often, whenever there's a vacancy on the Supreme Court, I, as a lawyer, get a letter in the mail from the Kansas Supreme Court saying, well, it's not always when there's a vacancy, whenever there's a vacancy on the commission, and when a commission nominee needs to be put forward, I get a vote. For whom would you vote on the Kansas Supreme Court nominating commission? And I get to choose. All of you non-lawyers in the audience, you have never received that letter, and you never will under the status quo. I get a voice in deciding who these 9 members are, but it's actually 5 of the 9. The governor appoints 4 laymen, and then the lawyers of the state of Kansas get to appoint the majority, 5. It is absolutely, indisputably true that lawyers have more power in the current system. Lawyers control the current system because we lawyers control the majority of the nominating commission. But it gets worse. There are examples, many examples, of where the commission, especially now that we can see what's going on and the meetings are public, where the 4 laymen will unequivocally say that one person is the most qualified justice. And then the lawyers huddle and they say, nope, we are absolutely not going to promote that person. And let me give you an example. He's currently sitting on the Kansas Supreme Court. His name is Caleb Stegall, one of the most qualified justices we've ever seen in Kansas. Graduated first in his class from KU Law School. The layman on the commission twice. He had to go before the commission 3 times. The first 2 times, the laymen on the commission were unanimous that Caleb Stegall should be on the Kansas Supreme Court. But both of those times, the 5 lawyers, for ideological, purely partisan reasons, saw him as too conservative. They bounded together to crush his nomination. Only when one lawyer vote was switched in the nominating commission did Caleb Stegall, one of our finest justices, squeak by. Lawyers have too much power.
Thank you. This will be the last question. Affirmative team, if you'd go first, please. If the judge is elected and they then stop using facts and the law to make decisions in favor of instead of partisan decisions, wouldn't that be reason to lose their license and be immediately removed from the court and practice? Please, yes.
Well, unfortunately, we have some examples under the current system of justices getting censured for lack of independence. We have investigations for justices holding political events at their house for a Democratic governor during an election cycle, sitting judges. The current system does not prevent the justices on the Supreme Court from the same types of violations of judicial canons that I think are being alleged that this would bring in. Those exist in any system because once you're on the Supreme Court, you have ethical responsibilities, you have judicial canons, you have rules of recusal, and ultimately you can be impeached. There have been instances where, like I said, in 2012 or thereabouts, there was a censure of one of the justices for meeting with a legislator during a very significant case before the court about what the legislature was doing to fix the problem. These are the types of issues we don't want in. And in every judicial selection system, you're going to need to police your judicial ethics, and we do that. There is a commission on judicial ethics that will actually make findings and make recommendations to the court for discipline. Ultimately, Supreme Court justices, though, once they get on, can only be removed by two ways. One is impeachment, and the other one is a lack of retention. Neither has ever happened, even though we've had these examples. And so I think that ultimately it's not unique to one system or another that we need an independent judiciary. I talked earlier about how Kansans can be trusted not just to pick judges, but to pick qualified judges. They can discern between what makes a good legislator and what makes a good county attorney. They can discern what makes a good school board president and what makes a good governor. And they can discern what makes a good, independent, competent judge for their judicial qualifications.
You repeat the question. Just want to make sure I got it right.
If a judge is elected and they then stop using facts and law to make decisions in favor of a partisan decision, would that be reason to lose their license and be immediately removed from the court and practice?
I think the short answer is yes. If a judge is not using the canons, or if they're not following the canons of judicial ethics, if they are just rendering opinions just for the sake of rendering an opinion not based on any law or any fact, then they're not in fact doing their job. So yes, well, I don't know if they'll lose their license immediately, but they would be subject to some form of discipline. Under the current, well, I believe if the amendment was passed, I believe there would be a part that's left out. So currently in the Constitution, the governor and the legislatures can be recalled if they are acting inappropriately. Currently, there's an exception for justices. That exception would not allow for their recall. If judges could now be elected, then that part of the Constitution would also have to be amended such that those judges could be recalled. That is conspicuously absent from the proposed amendment. So they don't provide an additional check that would typically be a part of the democratic process. So I do believe that the current system works fine, it works well. Lawyers, judges, generally, they self-police themselves. But they want to uphold the integrity of the bar and of the judges just as much as anyone wants their profession to be looked at highly. If a judge is not doing their job, they're not doing what they're supposed to do, then they're removed, especially if they are acting well outside the bounds of the law. So that's the answer.
Panelists, thank you very much for taking all those questions. We're now going to go to closing arguments. We'll start with the affirmative, and we're going to change it. Rather than 2 minutes, we'll give you 3 minutes. So.
We live in a democratic constitutional republic. It is a constitutional republic where the power of the people governs and is a restraining force upon abuses of power in any branch of government, but not in the judiciary in Kansas at the Supreme Court level. The Kansas Constitution proclaims, as has been mentioned in Section 2, all political power is inherent in the people, and all free governments are founded on their authority, the people's authority, end quote. We are supposed to be, as those words suggest, a government of the people, by the people, and for the people. That is true with respect to the executive and legislative branches in Kansas, but not in the Supreme Court. There it is government of the lawyers, by the lawyers, and for the lawyers. Now, the opposing team has said, well, we have to avoid that principle of government by the people when it comes to picking Supreme Court justices. We asked them, give us one example that is over the 100-year period until 1958 where the Supreme Court elections produced bias, or where there's in the last century of local elections in those 55 counties where there's been bias. Couldn't give us one example. And then we continually asked, why are the people not qualified to vote? Why are the people not qualified to check their Supreme Court, to select their Supreme Court justices? We finally heard an answer from one of the opposing team. His answer was, it's difficult for people to evaluate these very detailed issues. It's too boring. I don't think you, voters, have difficulty evaluating detailed issues when discerning between candidates. And frankly, some executive branch and legislative branch races are kind of boring too. The idea that you have ADD and your boredom will prohibit you from evaluating these candidates carefully is demeaning. Yes, some choices are boring choices, some choices are exciting choices, but the bottom line is the people are perfectly capable. And it's not just me suggesting or speculating that's true. A study by Bono and Hall looked at the success rates in the 22 states that elect their justices when the people are voting, and then compared that to the other system, and saw one really revealing factor, and that is the people tend to be very discerning. In states where the Supreme Court justices are elected, candidates with prior experience, with which most people would agree is absolutely a good thing to have in your justices, won an extra 4 to 5% of the voters, as compared to of the votes of voters, as compared to candidates without prior judicial experience. As they summarized their findings, quote, "We found that voters in state Supreme Court elections make fairly sophisticated candidate-based evaluations," end quote. The people are capable. We have heard no compelling argument as to why the people can't do this and why our principle of democracy should be abandoned when it comes to the judiciary. Thank you.
Article 3, Section 8 of our Constitution states, prohibition of political activity by justices and certain judges. No justice of the Supreme Court who's appointed or retained under the procedures of Section 5 of this article shall engage in any political campaign or hold political party. That will be gone if this amendment passes. The judiciary is not where political power, political influence, and political money should lie. Again, we have a direct voice in our legislature, in our top state offices. That is where direct democracy works in action. That is where, to the comments that were made earlier, that Mr. Floyd made in our primary comments to start this, is that they have different and distinct roles when it comes to our political process and the checks of government that we have. We want there to be a political voice and a direct election of our legislators. They are the ones that have the power to, again, look into the future. What do we need? What will make our lives better as Kansans? How can we move this state forward? How can we encourage business and industry and autonomy and people to want to live and work in our state and thrive here? When it comes to the judiciary, we need them to be able to look at the facts as they come to them, apply them to the law as it exists, not how they should want it to exist, not how their political donors want it to exist. We need the judiciary to stay independent, to stay out of politics, and again, it is an interesting hybrid system. It isn't like at the federal system. We're not saying these people, they don't get appointed and they sit there for life and that's it, and they're going to die in that seat and you're stuck with them, unless they do something really horrible that involves some sort of impeachment action. There is the retention election. That is such an important. I don't know why that is so dismissed and act like that's not a thing. That is on the ballot. People have their voice heard. Hundreds of thousands of Kansans. And to say that they're unopposed, there is a no. It's not like running if you run unopposed, you're running unopposed. There is no other choice. And that unfortunately happens a lot in these very partisan communities where people run unopposed and there is no other choice on the ballot. You could write somebody in, but there is a choice. You can vote no. You can have your voice heard. So we need to stop dismissing that as the retention vote being a nothing burger. It is not. It is such an important part of our system, and that is where the direct voice of the people is heard. without distinction of whether you're a lawyer or not a lawyer, your voice counts just as much as anybody else's every time those justices come back on the ballot. So again, we need to keep our justices, those 7 people that are charged with keeping us free and maintaining the law, free of political influence and money.
Ladies and gentlemen, would you please help me express appreciation? Thank you to our panelists, and I want to thank you. Thank you for proving that we can have a rational, calm, and intellectual debate on these issues. I appreciate you for doing that. So let's take a quick poll. How many of you are in favor? How many of you support the proposed amendment? How many support the proposed amendment to elect? How many oppose and want to retain what we're doing? I think it's a little bit to keep it the way it is. How many of you have changed your mind since you've been here this evening? Just a couple. Ladies and gentlemen, thank you so much for being here this evening. And please tell your friends. We will have this on our YouTube channel later in the week. Thank you so much. Thanks, Aimee. Thank you.